ಸರ್ ಕೇಳಿಸಿದ್ಯಾ? ಹಲೋ ಹಲೋ.
Sir, adjournments page wise from admission other side inform ಮಾಡಬೇಕು. Stay execution attachment fresh matter urgent ಇದ್ರೆ ಮಾತ್ರ ಮೂವ್ ಮಾಡಿ. ಅಲ್ಲ ಹೊರಟ್ರಾ ಮೇಡಮ್? ಫೋನ್ ಮಾಡಿ ಕೇಳದೆ ಇಲ್ಲ ನೀವೇ ಬರ್ತಾ ಇದ್ದೀರಾ, ನೀವೇ ಬರ್ತಾ ಇದ್ದೀರಾ ಅಂತಂದ್ರು. Four days ಇನ್ನೇನ್ 4 days ಅಲ್ವಾ?
Good morning, sir.
ಇದೆಯಾ ಮ್ಯಾಟ್ರಿ ಇವತ್ತು? ಬಂದ್ಮೇಲೆ ಕೊಡಿ. ಮ್ಯಾನೇಜ್ ಮಾಡ್ತೀನಿ.
Admissions tomorrow. You had appealed by the insurance company, there is a threat of execution taken up during this week.
Sir, I'm here for the respondent. These respondents are in a difficult financial conditions, but 22 matter, admissions, admission.
Yes. They'll come in the routine.
Fresh matters.
Yes.
Well, fresh matter.
What is the urgent?
My lord, court is not audible, my lord.
23, we are filing the appeal, my lord, till the notice not ordered.
Is any urgency?
Notice is not ordered, my lord.
Notice. Yes.
Fresh filing, my lord. It's been filed already 2 months, my lord. My lord. Already the execution proceedings have been initiated, my lord. They are expediting on the execution of the order, my lord. On the, my lord, 2000, we have filed it now, my lord. It's been 2023, my lord. MVC 2023.
Next.
Admission. Adjournments page wise from admission, page 7, 29 to 31. Page 8, 32 to 38.
37, yes.
Please, ma'am. It number 37, wait for the respondent claimant.
Yes.
Next week, kind of short accommodation.
Have you
Ravish.
informed the other side?
Other side,
Land Council Sri Gopal Krishna N for respondents 1 to 4 seeks time. Hence, stand over to 30th September.
Page 9, 39 to 44.
And for the second respondent.
Sri Rangegowda NR Land Council for the appellants seek to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
My lord, serial number 40, my lord.
40.
Appellant counsel Raghu R met with an accident, my lord. Kindly have it to 4 weeks time may be granted.
Sri
KV Naik.
KV Naik submits that Land Council on record for the appellant Sri Raghu R met with an accident and is taking treatment. Seeks time for 4 weeks. Hence, stand over to 21st October.
Please.
Serial number 44, my lord.
This
44,
matter I
41,
represent the
42.
respondent. This may be taken up next week. We are working out for a settlement. We'll try to report settlement before.
Yes, sir.
Sri Ananda KS for the appellants as well as Sri Ravi S. Samprati for respondent number 1 submits that the matter is likely to be settled. Seeks time. Hence, list on 23rd September.
Page 10, 45 to 48.
Serial number 47, my lord.
Yes,
This case, this appeal is already connected with 2894. The case is already 711 is proceeding. Kindly call on that date.
you are Mr. B. A. Ramakrishna.
I am Kailash Shankar, advocate.
Sri Kailash Shankar PS, Land Council for the appellant submits that MFA so and so
2894 already connected.
present appeal. Land
23.
Council also
Connect
states
ಆಗಿದೆ.
that
Already ಆಗಿದೆ ಮನೆ.
MFA so and so
Number heading
2894,
of
is
23.
scheduled to be listed on
711, my lord.
7/11. Full stop. Seeks to this the present matter also
Allah.
on the same day. Full stop. In
Please,
the light of the said submission, stand over to 7/11.
Other side inform ಮಾಡಿ.
Madam.
Page 11, 49 to 55.
Serial number 55, madam. That may be referred to local.
At request of Sri Giri Mallayya, Land Council for the appellant, the matter is referred to Lok Adalat.
Page 12, 56 to 62.
Till number 58, my lord.
58, yes.
We have to next week, my lord.
I am for respondent, my lord.
I inform the other side. Some of the papers are Kannada, my lord.
Land Council Sri Raju, yes, for the appellant seeks time to file translated copies of the documents over which he relies upon. Full stop. Hence, stand over to 21st October. 56, yes.
1 week time.
Why?
Inconvenience.
Huh?
Inconvenience.
What inconvenience? Next,
My lord, I am for the respondent, my lord.
yes,
Ashok Patil.
next.
Page 13, 63 to 68. Page 14, 69 to 70. For orders, serial number 1, K.R. Lingaraju, G. Lakshmi Rao.
Here for
There are
appellant,
two
my lord.
appeals filed by KSRTC and as well as 2 appeals by the claimants, my lords. The court has called for the records. But these matters may be posted immediately after the receipt of records because negligence is involved.
We'll admit the matter.
Already admitted, my lord. First matter had been admitted.
Admit. MFA 5086 of 2021. All the matters are admitted.
Maybe first matter, maybe only in first matter order had been passed. my lord.
First matter only.
Admit MFA 5086 of 2021 and MFA 5087 of 2021.
And also 6897.
Await
Other, there are 4 matters.
and also 6887 of 2021.
Another matter.
Extra. Await records from the consent tribunal. List all the matters on 21st October. All the matters on 21st October under the caption final hearing.
Please.
Serial number 2, Sumangala Swami. Serial number 2, Sumangala Swami.
No representation on either side on call. The appeal is of the year 2022. Full stop. To give fair opportunity, list on 23rd September.
Serial number 3, Jagdish HT.
And for the appellant in this case,
B. Hegde.
now for dispensation of notice to order.
Why it has to be dispensed with?
Let the insurance company has deposited the amount, the entire liability and the insurance company, my lord. Respond number 2.
Heard. Sri Jagdish HT Land Council for the appellant. Memo seeking dispensation of notice upon respondent number 1 is on record. Land Council Sri Jagdish HT submits that as the liability is fixed upon respondent number 2, comma notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
TCR may be this.
Admit. Call for the records from the consent tribunal. List the matter under the caption final hearing on 21st October.
Please.
Serial number 4, A.N. Krishna Swami.
And for the respondent.
Week's time may be granted. In fact, he was served in respect of the same address and he was represented before MACT. Now he is trying to avoid. 2 times I have taken. 3rd time I may have to take and then go for paper.
Furnish the requisites, Mr. Council.
A week's time may be granted.
Land Council Sri A.N. Krishna Swami seeks a week time to furnish the requisites. Full stop. Time as prayed for is granted. On furnishing the requisites, office to send notice to respondent number 2.
Much.
List on 28th October.
Serial number 5, K. Shantaraj. SV Hegde, welcome. Serial number 5, K. Shantraj.
No representation on appellant side no representation on either side on call. Three, SV Hegde Mulkan has not filed wakalat for respondent number 2 till now. Full stop. To give fair opportunity, a week time is granted. Full stop. No reason is afforded by the appellant for non-filing of certified copy of the impugned order Full stop. To give fair opportunity, a week time is granted. List on 21st October.
Serial number 6, XM Joseph.
Appear for the appellant, my lord.
Forward.
Deposit 5 lakhs, my lord. I'll file the memo in the counter, my lord. Acknowledgement.
You are Mr. XM Joseph.
I am on behalf of Exam, I am also on record, my lord. Anthony.
Anthony.
Heard Sri Anthony, Land Council who represents Sri XM Joseph, Land Council on record for the appellant. Full stop. Land Council states that acknowledgement of having deposited 50% of the award amount was filed in the office. Full stop. Registry to verify. Full stop. Await service of notice upon respondent number 3. List on 28th October.
Please.
Serial number 7, SB Mukandappa.
Appellant, my lord, I filed a memo along with cost paid to association library, my lord, as per quoted, and as well as my lord, I deposit entire amount, principal amount as well as the interest amount. My lord, yesterday, Saturday, my lord, I filed a memo along with order sheet maintained by the execution court. That memo has not been put up, my lord, kindly it may be see the. My lord, the principal amount, my lord, the and and 28/8/2024, my lord, 3,81,346 rupees check, my lord, the given before the execution court. And as well as my the interest part, my lord, 2,82,196 rupees, my lord, on 27/8/2024. The out sheet maintained by the execution court, my lord. The page number 3, my lord.
This shows that you have paid interest. Where is it?
Yes, my lord, the kind of see the order sheet, my lord, the page number 3, my lord. The as per order data, my lord, the one DD for rupees 2,82,196 rupees, my lord.
What's interest?
Yes, my lord, towards interest.
What about the principal?
The principal amount also is paid on 20th/8/2024, my lord. 20th/8/2024, my lord, the order sheet maintained.
Where is it found, Mr.
Yes.
Council? Land Council
Yes,
heard Sri.
my lord, the 27/8/24, my lord.
Yes,
Your name.
heard Sri. You are Mr. Mukundappa.
SB Mukkanappa, my lord.
Mesre,
Ah.
Mesre.
Naveen.
Sri SP. Heard Sri
My name is-
Naveen Kumar, who represents Sri SP Mukkanappa, Land Council on record for the appellant. Full stop. Memo file along with the certified copies of order sheets of the executing court reveals deposit of the award amount as well as interest. Next, also memo file recording payment of costs. Next, issue notice to
Respondent,
respondent.
kindly may stay the operation of the execute court.
Already stayed, no?
No,
Not stayed.
not it, past the. Stay order is not.
IA 2 of 2024 is filed seeking the court to stay the operation of the order, stay the operation of the award that is passed by the
This is-
employees' compensation passed by the Commissioner of Employees Compensation, Bangalore, in ECA 31 of 2019
Yes.
dated 4/12/2023. Stockland Council submits that the appellant is not, the petitioner appellant is not under liability to pay any amount, but the tribunal fastened the liability upon the petitioner appellant. Stockland Council also submits that the entire award amount along with interest was deposited before the executing court and proof to that effect is also filed, and thus the execution of the execution proceedings may be stayed. Full stop. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted. Full stop. Thus, further proceedings in all further proceedings in execution case number 300 of 2024 in ECA 31 of 2019, which is pending before
Chief.
Commissioner of Employees Compensation, Bangalore, shall stand stayed until further orders. Full stop. Issue notice to
Yes.
the respondent in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 4th November.
Serial number 8, DC Shivannegowda.
That time after objection must arise in that last occasion, my lord. In this case, what has happened, my lord, in the cast title, the office has raised the objection. In the cast title, it's Sri Rama General Insurance Company. The Rama General, Sri was left out. But in the award, there is a Sri Rama General Insurance Company. But yet other objection, my lord, in the wakalat, what we have put, the company seal is Sri Rama SHIRI. But here SHREE. That is the mistake. For that, my lord, the office has raised the 3 objections.
So what is the insurance company?
Sri Rama General Insurance Company, my lord. In the award, it is mentioned Sri Rama. Here also SHIRI, Sri Rama. The spelling mistake is there.
Heard, Sri B.C. Shivannegowda and counsel for the appellant. Full stop. An office objection is raised with regard to the discrepancy in the name of the appellant as found in the memorandum of appeal, the wakalat file and the impugned order. Full stop. Though in the impugned order, the name of the appellant is mentioned as the Rama General Insurance Company Limited.
In the award.
comma, in the award, it is mentioned as
Sriram.
Sri Rama General Insurance Company Limited. Full stop. The submission that is made by land counsel for the appellant is that the appellant is indeed Sri Ram General Insurance
Please.
Company. Ma Rama there, here Ram, only Ram. Insurance Company Limited, full stop. As the discrepancy is minimal, comma, the office objection in this regard, the office objections in this regard are overruled. Yes,
My lord, insurance company appeal challenging the quantum of compensation. My lord, as per the election card, the age of the deceased was 49 years. Therefore, applicable multiplier is 13 and not the 15 as applied by the court bill. Only on quantum, 50% I will deposit the amount.
we'll allow the claimants to withdraw that amount, 50%.
Please, ma'am.
IA 2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Chamraj Nagar, in MVC 161 of 2019, dated 6/3/2023. Full stop. Land Counsel Sri B.C. Shivanagowda submits that the tribunal, without applying appropriate multiplier, comma, awarded excess sum as compensation, and therefore an appeal is filed. Full stop. Land Counsel thereby seeks to stay the operation of the impugned award. Next, having considered the submission thus made, comma, this court is of the view that stay as straightforward is required to be granted, however conditionally. Next, thus, the execution of the award that is passed by the Motor Accidents Claims Tribunal, Chamraj Nagar, in MVC 161 of 2019, dated 6/3/2023, shall stand stayed until further orders on the appellant, petitioner appellant depositing 50% of the
What?
award amount along with accrued interest with, before the tribunal within a period of 4 weeks. Full stop. On such deposit, respondents 1 to 4 oblique claimants are permitted to withdraw their respective shares subject to the
Set up.
conditions imposed by the tribunal. Full stop. Issue notice to
Respond.
the respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 25th November.
Much.
Serial number 9, B. Pradeep.
For appellant, my lord, regarding office objection, my lord, original receipt should be should be produced, my lord, before tribunal, ECI, my lord, this matter. You have deposited amount before tribunal, my lordship. 2,58,854 rupees. I have produced the acknowledgement photocopy, my lordship. Original certified copy I intimated to company, they will. One more objection, my lord, interest portion, my lordship, 2,536 rupees as remaining balance, my lordship, interest portion. My lordship may be permitted to press 2 weeks time, my lordship, I will file.
That counsel Sri Mallikarjun Reddy representing Sri Pradeep B seeks 2 weeks time to comply the office objections. Full stop. Time as prayed for is granted. List on 14th October.
Meanwhile, deposit amount may be.
Next.
Serial number 10, B. Pradeep.
I am for appellant, my lordship. Statutory deposit today morning, I have deposited, my lordship.
Land Counsel Sri Mallikarjun Reddy representing Sri Pradeep B submits that statutory deposit has been made. Full stop. Registry to verify
Lala,
and to put up.
ಹಾಕಿದೀವಿ ನಮ್ಮ ಆಫೀಸ್ ಕಾಪಿ.
List on,
My lordship, seeking stay, my lordship.
let it be put up. List on 9th September.
Please, my lordship.
Serial number 11, hearing on IA, Renuka HR. Mushtaq Ahmed for R1.
For the respondent. In connected appeal, I am for the appellant. I have sought for the withdrawal of the amount.
Council on record is not keeping well.
I sought for
Matter
withdrawal
may
of
be-
amount, my lord. They have deposited 50% amount, they were deposited. I am permitted to withdraw the amount, my lord. They have challenged the quantum.
Will dispose of the appeal itself, Mr. Council. This appeal is of the year 2016.
Please, any date may be fixed, my lord, or
Day after tomorrow, my lord.
they are agreeable.
Okay, my
see
lord. I have it on day after tomorrow.
Notice for the.
Copy put something.
Notice to respondent. Respondent, we can order Renuka HR to take. Sri B.C. Shivanagoda, representing Sri Renuka HR Land Council on record for the appellant in MFA 7432 of 2016 submits that Srimati Renuka HR is unable to attend the court on this day due to the health, seeks time. The next para, the appellant in MFA 7432 of 2016 is the respondent in the connected matter, that is MFA 1443 of 2023. Full stop. Therefore, Srimati Renuka HR is called upon to accept notice for the respondent in the said appeal and file wakalat. Full stop. Wakalat to be filed within a week. List on 17th September.
Much.
Serial number 12, Ravi Shankar Shastri,
Appellant, my lord,
FS Dabali. for
my lord, claimant's appeal, my lord, as against dismissal of claim petition. There is a delay, my lord, due to, my lord, some communicational difficulties, my lord, that was happened.
What communication difficulty, Mr.
My lord, it was said, my lord, the case papers were sent for filing the appeal, my lord, through courier. Lord, that was not reached, my lord. Therefore, my lord, after COVID period, my lord, when it was inquired, it is noticed that appeal was not filed. Then, my lord, the appeal was, fresh copies were obtained and then appeal was filed. She may deny the interest and, my lord, kindly condone the delay, my lord, since some communications gap between the, my lord, parties and the learned advocate, my lord. Parties are from Mangalore.
How can it be communication gap for about 3 years, Mr. Council?
My lord, it have, but my lord, they
Yes, Mr. Dabali.
The claim petition itself has been dismissed.
Heard. Sri Ravi Shankar Shastri Land Council for the appellants as well as Sri F.S. Dabali Land Council for respondent number 1. Respondent number 2, Southern.
Oriented, served.
Respondent number 1. Full stop. IA 1 of 2021 is filed seeking the court to condone the delay of 1,117 days in filing the appeal. Full stop. Land Council Sri Ravi Shankar Shastri submits that due to communication gap between the petitioner's appellants and their counsel who appeared before the tribunal, the appeal could not be preferred within time. Full stop. Heard Sri F.S. Dabali also in this regard. Full stop. Gone through the contents of the affidavit given in support of the petition. Full stop. Though the delay is inordinate, having considered the fact that the appellants are the claimants in a motor vehicles claimants who claimed compensation as per the provisions of Motor Vehicles Act, and as Motor Vehicles Act is a welfare legislation, this court considers desirable to condone the delay as prayed for. Claim petition is dismissed.
yes, ma'am.
Yes, ma'am.
Full stop. However, the appellants will not be entitled for any interest for the period of delay of 1,117 days in case this court, through the judgment in the appeal, grants any amount as compensation to the petitioner's appellants. Next, admit, all for the records from the consent tribunal, list the matter under the caption final hearing on 28th October.
Great for me. But advocates are under difficulty, my lord, therefore, my lord, I will be grateful, my lord.
Serial number 13, Chandrasekhar R.
I appear for appellant also. Claimants appeal for enhancement. Serial number 13 to 13.8 connected matters. 161 days delay filing the appeal.
In the first matter, Sri Chandrasekhar R is appearing.
Yes, Miller.
Any objection for condoning the,
No, my lord. Interest may be denied and delay may be
you
continued.
have not filed wakalat in this. First
I have
matter.
not filed wakalat in this, and I have to file wakalat in the other matters also.
Write each matter separately. Third, Sri K.V. Naik,
Please.
Land Council who represents Sri Chandrasekhar R, Land Council on record for the appellant in MFA 8167 of 2022. Full stop. C. Ravi, Ravi S. Samprati waives notice for respondent number 2. Seeks time to file wakalat. Next. IA 1 of 2022 is filed seeking the court to condone the delay of 161 days in filing the appeal. Full stop. Third, Sri K.V. Naik, Land Council who represents the petitioner appellant, as well as Sri Ravi S. Samprati, Land Council who represents respondent number 2 insurance company. Gone through the contents of the affidavit given in support of the petition. Full stop. Having considered the ground urged, the delay as prayed for is condoned. Next.
Madam, serial number 13.5, my lord.
Thirteen point five, yes.
My lord, respond number 2, insurance company, my lord. Kindly direct to take notice, my lord, Ravi S. Samprati, my lord.
What is this office objection?
My lord, office objection, no.
13.5.
Process.
136 of 2022. Mr. Council, go through and comply the office objections.
My lord,
Two office objections, certified copy Kotila.
So far as MFA 8136 of 2022 and MFA 8137 of 2022 are concerned, the appellants therein are at liability to comply the office objections. Full stop. Office objections to be complied within 2 weeks.
please.
Next.
And again, my lord, 13.7, my lord, also.
13.7. Yes. Next matter, 8169. Court officer, 8169.
PF requisites has to be.
Sri Ravi S. Samprati is called upon to accept notice for respondent number 2 in MFA 8169 of 2022 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri Ravi S. Samprati.
Please.
Next paragraph. Sri Ravi S. Samprati has not filed wakalat for respondent number 2 in MFA 8188 of 2022. Full stop. Time for a week is granted. Full stop. List all the matters on 21st October.
Serial number 14, H.C. Rishabhendraya. Sarita Kulkarni for respondent.
14.1, I appear for, there's a delay of 259 of days.
Number
470.
Delay may be condoned.
Yes, where is the other? In the first matter, there is delay of 75 days.
We condone, my lord.
In the second one,
259 days.
yes. Hearing,
No,
We'll have it on next.
date may be fixed, my lord, we'll go through.
IA 1 of 2023 in MFA 4388 of 2023 is filed, seeking the court to condone the delay of 75 days in filing the appeal. Full stop. Next.
Put up, sir.
In
Yeah.
next parama, in MFA 478 of 2024, IA 1 of 2024 is filed, seeking the court to condone the delay of 259 days in filing the appeal. Heard. Sri H.C. Rishabhendraya, Land Counsel for the petitioner in IA 1 of 2023 in MFA 4388 of 2023,
Student from you.
as well as your Sarita Kulkarni,
I appear for, on behalf of Sarita
your
Kulkarni,
good name, ma'am,
Sumitra, my lord.
as well as Srimati Sumitra, who represents Srimati Sarita Kulkarni, Land Counsel on record for the petitioner appellant in IA 1 of 2024, petitioner's appellant summa in IA 1 of 2024 in MFA 478 of 2024. Let's stop. Gone through the contents of the affidavits given in support of both the applications. We'll stop. Having considered the ground search, both the applications are allowed. Next. You take notice in the connected matter, Mr. Counsel.
Yes, ma'am. Yes, ma'am.
Sri H.C. Rishabhendraya is called upon to accept notice for respondent number 3 in MFA 478 of 2024 and file wakalat subject to entrustment of the case otherwise by respondent number 3. Wakalat to be filed within 2 weeks. Full stop. Issue notice to respondents 1 and 2 in MFA 478 of 2024 on furnishing the requisites. List both the matters on 28th October. Mature.
Serial number 15. L. Srikanta Rao, Nagaraj Reddy.
Been made, I file it within a week. And as far as the application is concerned, the service is complete now. The records may be called for, and it may be posted in next week, we'll close the matter. Liability is questioned.
Heard Sri L. Srikanta Rao, Land Council for the appellant, as well as Sri Nagaraja Reddy D, Land Council for respondent number 1. Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 30th September.
Short date. She has lost only son-in-law, she has lost, and only
Let us read with the
Bangalore.
we have posted the matter. Yes.
Serial number 16, Shankar Reddy,
I am for R1, my lord, in this case.
Manjunath ND.
I have no objection to release the 50% of the deposit. Only quantum in question, madam.
A3 of 2024 is filed by the claimant seeking the court to permit him to withdraw the deposited amount. Next, heard. You are Mr. Manjunath D.
Please, my lord, I am Manjunath, my lord, for R1.
Sri Manjunath ND, Land Council for the petitioner claimant, as well as Sri Shankar Reddy C, Land Council for the respondent insurance company.
Not responding. Appellant. Appellant in that.
You are for the insurance company. You are the respondent in the interlocutory
Yes,
application. Respondent insurance company. Full stop. Land Council Sri Shankar Reddy C submits that as 50% of the award amount is deposited and as the quantum is in dispute, he has no objection to permit the claimant to withdraw the amount as prayed for. Full stop. Having considered the submission thus made, the present application is allowed. Full stop. The petitioner oblique claimant is permitted to withdraw the deposited amount without furnishing any security, subject to the conditions, if any, imposed by the tribunal through the impugned order. Subject to the conditions imposed by, if any, imposed by the tribunal through the impugned order. The tribunal is directed to release the amount on due identification. Next. You have to furnish the requisites for issuance of notice to respondent.
Next. I have to take steps.
Furnish the requisites. Land Council Sri Shankar Reddy C seeks time to furnish the requisites. Time for a week is granted. On furnishing the requisites, office to send notice to respondent number 3. List on 28th October.
Serial number 17, Guru Prasad KT.
This matter, I filed a memo to dismiss the claim petition as withdrawn, appeal as withdrawn.
Where is the memo? Where is the memo? for
Memo,
withdrawal?
memo filed on 29/7 itself.
It is not put up, we'll see, pass over them,
Pass over.
verify with the office.
Serial number 18,
Upper for
Nanjunda Swami.
appellant, my lord, upper for appellant, my lord. There is a delay, my lord, and also, my lord, kindly seeking stay, my lord. The appellant is a respond number 2 before the trial court, my lord. Admittedly, my lord, he has sold the vehicle, subject vehicle, my lord, to the petitioner himself, and that is respondent here in himself. He has respondent number in his evidence PW1. He has admitted that he has purchased the property and he has been using the vehicle since 2009, my lord. The tribunal, my lord, without considering the same, my lord, as fast on the liability and the petition appellant hearing, my lord, against that, my lord, this MFA is filed. They have filed an execution petition. Kindly, my lord, stay the impugned till, my lord.
You are Mr. Nanjunda Swami.
I am for Nanjunda Swami, my lord.
Your good name, Mr. Counsel.
Nanjunda Swami, Nanjunda Swami.
Order. Sri Nanjunda Swami N, Land Counsel for the appellant. Next, IA 2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Mysore, in MVC 895 of 2022, dated 7/12/2023. Full stop. Next, Land Counsel Sri Nanjunda Swami N submits that the appellant sold the offending vehicle to the claimant long back, full stop. Therefore, the petitioner appellant was not at liability to pay any compensation, full stop. But without considering the plea taken, the tribunal fastened liability against the petitioner appellant, and therefore the impugned award is required to be stayed. Next, having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted. Next, thus the execution of the award that is passed by the Motor Accidents Claims Tribunal, Mysore, in MVC 895 of 2022, dated 7/12/2023, shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount along with
Perfect.
accrued interest before this court within a period of 4 weeks.
My lord,
Yes, on such
50%.
deposit, the registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Full stop. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 7th November.
My lord, one submission, my lord. Kindly, my lord, 20%, my lord. We are not liable to pay.
Yes, we are not asking you to pay to the claimant.
Then they are not entitled to receive them
Yes.
until this. My lord, deposit, my lord, 6 weeks time may be granted for deposit.
Within a period of 6 weeks. Yes.
Great.
Serial number 19. Girish,
Fair
all
for
that?
appellant.
Respondent.
Mala, this matter is already settled in Lok Adalat, Mala.
Delay may be condoned.
Delay may be condoned and referred to Lok
Lok
Adalat.
Adalat.
Third, Ms. Anupama, who represents Sri Girish B. Baldari, Land Council on record for the appellant, as well as Sri Jagdish P.S., Land Council for respondents 1 and 2.
Only one, my lord.
Respondent number
Number
1.
one.
You are appearing for?
I am actually, my lord, this honorable court has directed me to appear on respond number 1. My London friend has already filed wakalat, my lord, therefore, my lord, I'm representing SBI, my lord, there is no liability.
IA 1 of 2024 is filed seeking the court to condone the delay of 149 days in preferring the appeal. Please stop. Land Council Sri Jagdish PS for respondent number 1 submits that the matter would be settled before the Lok Adalat. Full stop. In the light of the submission thus made, the delay as prayed for is condoned. Next, the matter is referred to Lok Adalat for settlement. Achha.
Serial number 20, Pradeep B.
This case, my lord, challenging the quantum of compensation, my lord. The injured was an HR admin in Apparel India Limited. After the accident, my lord, he is continuing the same job. 8 lakh rupees has been awarded toward disability and damages, my lord. That we have challenged before.
Heard Sri Pradeep B. Land Council for the appellant. IA 2 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal Bangalore in MVC 2000 of 2016 dated 1/7/2023. Next, Land Council Sri Pradeep B submits that though the claimant is continuing his occupation, continuing his job and is earning, the tribunal awarded huge amount under the head loss of future earnings, and therefore an appeal is filed. Land Council thereby seeks to stay the operation of the impugned award. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Thus, the execution of the award that is passed by the Motor Accidents Claims Tribunal Bangalore in MVC 2000 of 2016 dated 1/7/2023 shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount along with accrued interest before the tribunal within a period of 4 weeks. Next, on such deposit, the respondent claimant is permitted to withdraw the same without furnishing any security.
Only 4 lakh they may permitted to it. Entire 8 lakh I have challenged, not 14 lakhs is the award. Deposit 50%, not 14 lakhs is there, 7 lakh around, my lords, if I have to deposit 50%. Out of that, my lord, 50% they may permitted to.
What is the total award amount?
Total award, my lord, 14 lakhs 13,763. During the course of cross-examination, he has admitted that, my lord, after the accident, his salary has been increased.
On condition that the petitioner appellant deposited, you had said 50%, you remove that. On condition that the petitioner appellant deposits a sum of rupees 8 lakhs. Next, on such deposit, the petitioner appellant is permitted to withdraw. No, along with accrued interest, you remove it. You deposit total sum of rupees 8 lakhs.
6 lakhs. 6 lakhs is disputed amount only. 8 lakh, my lord, the MSCT awarded damages, disability 8 lakh, my lord.
Whatever the
Total amount is, my lord, 14 lakhs 13,000. 14 lakhs 30,000, my lord.
Deposit that amount.
6 lakhs 13,000 would be, I am ready to deposit, my lord, 6 lakh.
How can it be? 50% also will be exceed no. 50% and accrued interest will exceed.
But my lord, entire 8 lakh I am challenging. 8 lakh awarded disability and damages has been challenged by me, my lord. Remaining amount, my lordship may direct, my lord.
Deposit 7 lakhs. Deposit
Please.
7 lakhs.
Please,
Permitted to withdraw the entire.
please.
Issue notice to The tribunal is permitted to, the petition, the respondent claimant is permitted to withdraw the deposited amount without furnishing any security, subject to the conditions, if any, imposed by the tribunal through the impugned order. Full stop. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 19th November.
Serial number 21, Tejas N.
Appearing for appellant, my lordship. Is a case of death.
Sri P.B. Raju is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of Sri P.B. Raju. Full stop. Issue notice to respondent number 1 in the appeal as well as in IA 1 of 2024 on furnishing the requisites. List on 19th November.
Serial number 22, R. Shashidhara.
Appeal filed by the owner of the vehicle. Legal rights of the original owner. Original owner is no more.
You have not filed the death certificate.
The death certificate I not, I will furnish the death certificate. Recently I got the death certificate.
Land Council Sri R. Shashidhara seeks time to furnish the death certificate of
Dodda Mallappa.
Dodda Mallappa. Hence list on 25th September.
Execution is filed. They sought for attachment of the only agriculture land, my lord. Any short date may be given, next week,
List on 17th September.
please.
Serial number 23, Tejas N.
Appearing for appellant. Case of injury.
You are Mr. Teja Sen.
Rohan.
Heard Sri Rohan, who represents Sri Tejas N, Land Council on record for the appellant. Sri B. Pradeep is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri Pradeep B. Issue notice to respondent number 1 in the appeal as well as in IA 1 of 2024 as on furnishing the requisites. List on 25th November.
Serial number 24, D. Vijay Kumar.
My lord, I am for the appellant, my lord. Appeal by the insurance company, my lord, challenging their liability. the claimants are the occupants of the car. It's a private car and the vehicle is issued with only act only policy. But the act policy may not cover the risk of a passenger. Therefore, they are not a third party. The insurance company is not liable to pay the compensation.
Third, Sri D. Vijay Kumar, who appears through VC and represents the appellant. Next, IA 2 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal Kundapura in MVC 910 of 2019 dated 12/3/2024. Full stop. Land Counsel Sri D. Vijay Kumar submits that though the claim of the respondent claimant was not covered under the terms and conditions of the policy, yet the insurance company fastened liability against the petitioner appellant and therefore an appeal is filed. Which Land Counsel thereby seeks to stay the operation of the impugned award. Next, having considered the submission thus made, this court is of the view that stay as praetor is required to be granted. Thus, the operation of the award that is passed by the Motor Accidents Claims Tribunal Kundapura in MVC 910 of 2019 dated 12/3/2024 shall stand state until further orders on the petitioner appellant depositing 50% of the award amount along with
Before High Court, my lord.
Along with accrued interest before this court within a period of 4 weeks. On such deposit, the registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Full stop. Issue notice to respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 25th November.
Much obliged.
Serial number 25, Sushmita.
Happy for opening this case, my lord. Filing a memo for dispensation of notice to R1.
Third, Ms. Susmita G, Land Counsel for the appellants. Land Counsel files a memo seeking dispensation of notice upon respondent number 1. Why it should be dispensed with?
They've placed ex parte in MACT, my lord.
Land Counsel states that as respondent number 1 remained ex parte before the tribunal, hence a notice to respondent number 1 may be dispensed with. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
For R2, kindly notice may be issued, my lord.
Sri Ravi S. Samprati is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of respondent number 2. List on 28th October.
Much obliged.
Part heard matter, serial number 26, Mahadev Swami. D. Vijay
My lord,
Kumar.
I am for the appellant in 26.1. I have filed appeal, my lord, challenging the liability to pay the compensation. I am ready for argument. And as far as R2 is concerned, my lord, I am going to file a memo in the office. Notice to R2 may be dispensed with. Because I already taken notice on 3 occasions. And even before the tribunal also, he has not contested the matter. And there cannot be any liability on him also because the insurer and the claimant are both one and the same.
You
Right.
file a memo, Mr. Council.
I'll file it in the office, my lord, today only.
But before the trial court, the respondent number one has contested the petition.
Respondent?
Number one has contested before the trial court also.
He has not filed the witness statement, nor cross-examined the
You are
witness.
for respondent number one.
I am the claimant in the first appeal.
The connected matter, you are for respondent number one.
Yes, my lord. In the respondent number two is the owner of the vehicle.
Vehicle. He contested,
Yes, yes, my lord.
Mr. Vijay Kumar,
Please, my lord.
Sri Mahadev Swami states that the respondent number two contested before the tribunal.
My lord, mic may be a bit nearer to this, my lord, kindly, not able to clear the problem. My lord, here, my lord, the respondent number one before the tribunal, my lord, he is not the owner. The claimant himself is the insured. I am not concerned about who is the owner, because the insured himself is the claimant. He is in the car, occupants of the car. He has claimed compensation. And kindly see the petition averment, issues, evidence, everything. What he claims, my lord.
Whatever it may be, Mr. Council, the said party was on record before the tribunal.
But,
And
my lord,
he
I'm going to
contested the
dispense with, my
matter.
lord. I'm going to dispense it because he has not contested the matter before the tribunal, though he has appeared through the council.
Yes, you file a memo.
I'll file memo, my lord.
Land Council Sri D. Vijay Kumar, who is appearing for the appellant in MFA 5935 of 2016, seeks time to file a memo
Call it tomorrow, my lord.
regarding dispensation of notice upon respondent number two. Hence, list on
Any
9th
shortest
September,
date.
next Monday.
Much obliged.
Serial number 27, Pradeep KC. Part-heard matter, Jagdish HT for respondent.
You write, remove from the caption part-heard and list on 9th September. Remove from the caption part-heard and list on 9th September. Yes, Mr. Council.
Already arguments for done minutes.
Huh?
It is due for the arguments of all 2 minutes.
Twenty-six is not in our roster. Why it is so? Remove from the caption part-heard and list before the appropriate bench having provision to deal with. Item
Hello.
number 26. Yes. Yes, Mr. Council.
27, Pradeep KC.
Appear for appellant, my lord. It's a case of injury, my lords.
Yes.
On the last occasion, my lords, respondent number 2 did not appear. Our arguments already addressed, my lords. There is a liability dispute 2 minutes, which is covered by the Mukundan Devan case.
What is the dispute regarding liability?
Liability is saddle and the owner of the vehicle, my lords. Since it's the vehicle weight is less than 7,500 kgs, it will be covered. It's a light scoot vehicle, my lords, 3,900 kg. The case on hand.
last time you forwarded the copy of the driving license.
Please, madam.
We have got the recorder. Where is the other side counsel?
HT Jagdish,
Not
serial number
representing.
27.
Last occasion also is absent.
The matter, let him come, we'll
Please.
dispose. We'll call 2:30. Yes.
Possible. Serial number 28 for dismissal. Karthik V,
Kindly pass on.
Just Lingaraju.
On record consider held up in the another quarter.
Serial number 29. Gurudev Prasad KT, B Pradeep for R2.
Referring for the second respondent, madam. In this case, madam, TCR is required in this case.
No representation on appellant side on call. Full stop. Learned counsel Sri Pradeep B for respondent number 2 submits that records of the tribunal are required. Full stop. Hence call for the records from the consent tribunal. Placed on 21st October.
Serial number 30, Sadashiva KG, Gopal Krishna N for respondent.
Correspondent.
In this case, my lord, I will direct take notice, but in the connected case, my lord, Mr. Sitaram Rao is appearing for R4, United India. So my name may kindly be deleted and his name may be kindly be shown.
Learned counsel Sri SV Hegde Mulkund submits that he was directed to take notice for respondent number 2, but for the same party, Sri BC Sitaramarao is appearing in the connected appeal. Full stop. In the light of the submission thus made, Sri BC Sitaramarao is called upon to accept notice for respondent number 2 in MFA 2961 of 2021 and file wakalat. Full stop. Appellants to serve copies of appeal papers at the chambers of Sri BC Sitaramarao. Wakalat to be filed within 2 weeks. Full stop. Next paragraph. As Sri BC Sitaramarao is on record for respondent number 4 in MFA 6286 of 2022, office is directed not to show the name of Sri G.S. Marulaya in the cast list. We'll admit both the matters.
Let's may make one submission, my lord. I may be permitted to produce additional evidence in regard of the matter.
Fine.
Please, ma'am. Yes.
Admit both the appeals. List both the matters and the caption final hearing on 21st October.
Not obliged.
Serial number 31, Prakasha HC, D Vijay Kumar.
And for the respondent, ready, my lord.
Serial number 31,
I am for the respondent, my lord, ready, my lord.
No representation on appellant side on call. There was no representation on appellant side, even on 8/8/2024. Full stop. Hence, list the matter under the caption for dismissal on 9/9/2024.
Much obliged.
serial number 32, Prakasha HC, B Pradeep.
Second respondent.
No representation on appellant side on com. There was no representation in the even on 8/8/2020. Hence, list the matter under the caption for dismissal on 9/9/2020.
Serial number 33, yes, Raju,
For the appellant,
SP Mahesh for R1.
this case, madam, records may be called for.
Heard Sri Raju, yes, learn counsel for the appellant. Admit and call for the records from the consent tribunal. List the matter under the caption final hearing on 14th October.
Cell number 34, Kavita HC.
Representing for
Tejaswi.
respond number 4, Your Lordship.
2 weeks time, take instruction in appellant.
Have you deposited the amount?
Don't,
Huh?
don't,
Huh?
I take instruction in appellant, 2 weeks time.
This is 2021 matter. Stay was granted in the year 2021. Huh?
Please,
Your good name, Mr. Counsel.
Baira Reddy.
Heard Sri Baira Reddy, learned counsel who represents Srimati Kavita Hetsi, learned counsel on record for the appellant.
What are my ನೋಡಿ.
Owner is in appeal, Your Lordship.
On a query posed by this court, next one here. As per office endorsement, the appellant has not filed acknowledgement of having deposited 40% of the award amount as ordered. Full stop. Learned counsel Sri Baira Reddy submits that he has no instructions from the party about the deposit of the amount. Stop. Granting stay of the operation of the impugned award, this court through orders in IA 1 of 2021, dated 17/12/2021, ordered the appellant to deposit 40% of the award amount before the tribunal within a period of 8 weeks. Full stop. Thus, Sri Baira Reddy is directed to get specific instructions from the appellant about the deposit of the amount. Full stop. In case the amount as ordered is not deposited by now, the appellant would be at liability to pay costs of ₹10,000 to Paralympics Association of India. Full stop. Released on 10th September.
Serial number 35, Sanat Kumar KM. Radha.
In this case. Claimant's appeal for enhancement. Death of a father. Claimants are the daughters. Death of a father. Date of action is on 23/12/2016. The tribunal has awarded only sum of ₹15,000 as an towards the funeral expenses and 15,000 towards loss of estate and 80,000 towards the consortium. And has not awarded any amount towards the loss of dependency by holding that they are the married major and married daughters. My lord, this honorable court, the division bench of this honorable court has held that in MFA 118 of 2018. Has held that even married sons and daughters, major married sons of the deceased are entitled for compensation under the head of loss of dependency. Para 8 of the judgment, my lords. May I read? The trial court in para 28 and 29 has discussed in this regard. my lord.
Are there any decisions of the Honorable Apex Court on this aspect?
This regard, my lord, that the division bench also of this honorable court has relied on the judgment of the honorable Supreme Court in National Insurance Company versus Birender, 2020 SC.
Copy of the decision, Mr.
Please.
Heard, Sri Sanat Kumar, KM, Land Council for the appellants as well as your good name, Amma,
BP Radha.
as well as Miss BP Radha, Land Council for respondent. Admit, list the matter under the caption final hearing on 10th September, next week, posted to next week.
Much.
Serial number 36. Sushmita.
Appeal by owner.
A. Vishwanath for R1.
Appeal by owner.
1 to 4, my lord.
I am representing insurer, my lord. Owner is made liable, therefore before this, they are before this.
Challenging finding of tribunal paragraph 21, my lord.
NCR release, sir.
Who is appearing for the insurance company? So on what ground you were absolved from the liability?
He was proceeding as a passenger in the goods vehicle, my lord, whose risk is not covered.
Our contention she was coolie. And let's,
Will admit and list for final hearing.
please.
Heard. Sri Gopal Krishna N, Land Council who represents the appellants in MFA 6969 of 2021. As well as Sri S. Krishna Krishore, Land Council for respondent number 5. Land Council who represents the insurance company. Next, admit both the appeals. List both the matters under the caption final hearing. Records received.
Yes.
Under the caption final hearing on 16th October.
Please.
Serial number 37, adjourn. 38. BS.
My lord, I appear for the appellant, my lord. The insurer appeal and liability, my lord, of FIR is changed and subsequently records may be necessary and it may be posted for hearing, my lord. Records may be called under.
Heard, Sri B.S. Umesh, who appears through VC. Let's admit. Call for the records from the consent tribunal. List the matter under the caption final hearing on 21st October.
Records may kindly be called, my lord.
ಆಗಿದೆ sir, ಆಗಿದೆ.
Oblige.
Serial number 39, 40, adjourn. 41, A. Srinivasaya. B. Pradeep for respondent.
For second respondent.
You have not filed Wakalat, Mr. Pradeep.
Fine.
No representation on appellant side on call. To give fair opportunity list on 9/9.
Serial number 42, Gurudev Prasad, KT, HC Shabhendraya.
For respondent number 2 in this case, my lord, and records are necessary, my lord. There is negligence
At request of Sri H.C. Rishabhendraya and counsel for respondent number 1, comma, call for the records from the consent tribunal. List on 21st October.
Serial number 43, N.R. Rangegowda, Nagaraj, for respondent. Serial number 43,
R2 Ravi Samprati has filed Wakalat, my lord, my name may be deleted.
No representation on appellant side on call in both the matters. Full stop. As Sri Ravi S. Samprati is on record for respondent number 2, comma, office is directed not to show the name of Sri B. Pradeep in the cost list. So list both the matters on 9.
serial number 44, adjourn. 45, A.S. Girish,
Lordship,
P.
appellate.
Raju, for
Kindly refer to the matter of the Lok Adalat, both side we are,
For the respondent number 2 in this matter, my lord.
the insurance company.
Sri Ravi S. Samprati is on record. Wait. Yes, Mr. Counsel.
Lordship, kindly refer the matter to the Lok Adalat.
At request of Sri A.S. Girish and counsel for the appellant, the matter is referred to Lok Adalat for settlement.
Grateful, my lord.
Which one? 41. What did you write in 41? Amma? 41. At request of Sri Srinivas Ayya A. Land counsel for the appellant, the matter is referred to Lok Adalat for settlement. Yes.
serial number 46, Prakash M.H., Janardhan Reddy, respondent.
I am for the insurance company.
No representation on appellant side on call. To give fair opportunity, list on 17th September.
47, adjourn. Serial number 48, B. Pradeep, P.C. Satish Kumar, for respondent.
This case, my lord, challenging the quantum of compensation.
Yes.
Whether the claimants have filed an appeal or not, I will once cross check, my lord.
Heard Sri Pradeep B. and counsel for the appellant. No representation on respondent side on call. Admit list the matter under the caption final hearing on 11th September.
Obliged.
Serial number 49,
Yeah, for appellant,
30,
kindly refer to Lok Adalat, my lord.
B. Pradeep.
At request of Sri Satisha T. and counsel for the appellant, the matter is referred to Lok Adalat for settlement.
50 also. 50, 51, 52,
50, 51,
52, my lord.
Serial number 53, Vishwanatha K.
We appear for order.
The injury case, my lord, the connected matter is before the division bench, my lord. In MEC number 215 bar,
Have to take steps, Mr. Counsel.
yes, my lord, I may be permitted to file.
Sri Vishwanatha K. and counsel for the appellant submits that the connected matter is before the division bench. Full stop. Seeks time to take steps for clubbing both the matters. Full stop. Hence, list on 21st October.
Number 8. Serial number 54, Vijay Kumar D.
Represent for respondent number 1 and 2, madam. Kindly call for trial court record. Company is challenging liability and negligence also.
Heard Sri Satisha T. and counsel for respondents. Full stop. Call for the records from the consent tribunal. List on 4th November.
Serial number 55 adjourn. 56 Ashok N Patil, Kavita HC. Serial number 56.
No representation on either side on call. The appeal is of the year 2021. But the appeals are of the year 2021. To give fair opportunity list on 4th September.
Serial number 57. HC Rishabhendraya.
My lord, kindly have fix a date, my lord, because I'm ready to argue the matter.
Argue the matter.
The other party says,
Yes, please proceed.
next time. Kindly have
Yes, Rajshekhar.
2:30.
Serial number 57.
That pass over.
58 adjourn. 59 Kavita HC. D Vijay Kumar. Serial number 59.
No representation on appellant, no representation on either side on call. To give fair opportunity list on 4/9.
Serial number 60. B Pradeep S Mohan for R1.
Complaint in this case challenging the liability on the
Yes.
ground that my lord, the passenger carried in the goods vehicle. It's a case of death, my lord, 13-year-old boy who was traveling in a Tata Ace goods vehicle as a passenger, my lord. The risk of passenger is not covered in a goods vehicle. Therefore, my lord, the liability would be fastened against the owner of the vehicle. They contended that, my lord, he was a pedestrian. The complaint, the police records I had to read the records, my lord, in the Kannada, it is in Kannada language. If my lordship can translate me, or otherwise I had to file a relevant. Please.
ಅರವತ್ತಕ್ಕೆ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
The finding is there in para number 13, 14.
So on what capacity he was traveling is not known.
Was a passenger, my lord. Admittedly, my lord, in their evidence also, they have stated that PW1 and complaint, everything, my lord, inter police records, so it goes to show that, my lord, may read the evidence of the PW1. PW1, my lord, was a father of the deceased. I am the petitioner in the above case. I am fully conversant with the facts of the case. I submit that the deceased Bhagavan, son of Sannappa, is my son. He was hale and healthy prior to the date of accident. I submit that on 14/5/2015, my son Bhagavan was traveling in the Tata S bearing number from Kenguravahatti to Devarahalli village on the demand of the first respondent, and the said vehicle was driven by the first respondent while going near Devarahalli village in Kadur Taluk, in between Kengadurabatti Halli, Devanahalli road. At about, my lord, due to the fault of the first respondent, the deceased Bhagavan was thrown from the said vehicle, fell down on the road, and due to the said accident, my son was sustained injuries and succumbed to the same. Was a 13-year-old boy, my lord.
So we'll order pay and recover.
No, my lord, the apex court in recent judgment of the apex court in Balakrishna Chauhan, in all the cases, my lord, pay and recovery order could not be passed. As per the section 147, there is no liability at all. If 149 subclass 2 defenses, my lord, then my lordship can say it's a violation of breach of terms and condition of the policy. Here, my lord, there is no coverage at all. The apex court has been observed, para 10, my lordship. Para 8 and 9 is the discussion. Fact and circumstance of the case, my lord. The similar case, my lord. Para 8,
Even in this case, pay and
this
recover.
case, my lord, but the fact of present case, like my lord, last conclusion, but para 8 may kindly be seen. Para 8. The only aspect of our consideration herein is as to whether in the factum circumstance of the present case, in an order to direct the insurance company to pay and recover is required to be made. On this aspect, the law is well settled that if
Having observed this, the court ordered pay and recover.
but my lord, in this case, my lord, the finding is given, therefore keeping in all aspect in view of not making this case as a precedent. Para 13, my lord, it is not a precedent, but only serve the ends of justice to the fact of this case. We direct the respondent number 1 insurance company to deposit the compensation amount before the MSCT within 8 weeks from the date of receipt of the copy of this. It is not a precedent, my lord, apex court has observed. Para 8, my lord, a pay and recovery could not be passed where there is no liability to pay the compensation.
Then we should also say same thing.
Lord, but
Heard.
147 is clear, my lord, section 147.
Heard. Sri Pradeep B, land counsel for the appellant. Full stop. Though Sri Mohan S is on record representing respondent number 1, land counsel failed to make his appearance. Full stop. Next. Disputing its liability to pay compensation, the insurance company is before this court challenging the order that is rendered by the Motor Accidents Claims Tribunal, Kadur, in MVC 488 of 2016, dated 29/5/2020. Good stuff. Undisputedly, a boy by name Bhagavan died in a road traffic accident that occurred on 14/5/2015. Good stuff. By the date of death, comma, he was aged about 13 years. Next page. The father of the deceased Bhagavan, within brackets hereinafter be referred to as the deceased for brevity, brackets close, moved an application claiming compensation. Full stop. His version is that on 14/5/2015, while the deceased was traveling in a Tata Ace vehicle bearing registration number KA 13B 0308, from Kenguru Barahatti to Devanahalli village, comma, he was thrown out from the said vehicle due to which he sustained grievous head injuries and died due to the injuries sustained. Full stop. Next. The appellant herein resisted the claim, raising a plea that the terms and conditions of the policy does not cover the risk of the deceased. Full stop. The tribunal, however, fastened liability against the appellant insurance company and ordered it to pay compensation of rupees 5 lakhs. Full stop. Next pair. Arguing the matter, Sri Pradeep B for appellant contends that the deceased was traveling in the offending vehicle as gratuitous passenger and the risk of a gratuitous passenger was not covered under the terms and conditions of Exhibit R2 policy, and therefore the tribunal ought to have exonerated the appellant insurance company from liability, but it did not do so. Full stop. Land Council states that when there is clear violation of terms and conditions of the policy, no liability can be fastened against the insurance company. Full stop. Next pair, admittedly by all the evidence produced, it is clearly brought on record that while the deceased was traveling in the offending vehicle, he was thrown out from the said vehicle. Thereby he fell on the ground, sustained injuries and died. Full stop. Though the first respondent, though the owner of the vehicle took a plea that the deceased tried to board the moving vehicle, lost control and fell down, but the convincing evidence produced by the claimant speaks otherwise. Full stop. The manner of happening of accident was established in clear terms and that it occurred while the deceased was traveling in the offending vehicle. Full stop. Next, it is not the version of either the owner of the vehicle or the claimant that Exhibit B2 policy covers the risk of a gratuitous passenger. Full stop. Submitting that no liability can be fastened as the risk was not covered under the terms and conditions of the policy, learned counsel for the appellant relied upon the decision of the Honorable Apex Court in the case between Balu Krishna Chavan versus Reliance General Insurance Company Limited and others. Full stop. In the said decision, dealing a similar situation, that is where a gratuitous passenger was traveling in the offending vehicle, the Honorable Apex Court at paras 8 to 14 of the judgment held as under. Next, in the case on hand, a boy of 13 years old died in a road traffic accident, that too due to the rash and negligent driving of the driver of the offending vehicle. Full stop. The owner who validly insured his vehicle, permitted the deceased to travel in the said vehicle. Full stop. Though the deceased was traveling as a gratuitous passenger, yet having considered the fact that the boy lost his life at a tender age and that his father has to lead his entire life
Correct, Adu.
in grief, this court is of the view that, and further taking into consideration the contents of the aforementioned decision, where exhibiting a view that the Motor Vehicles Act is a welfare legislation, ordered the insurance company to pay the amount awarded granting the liberty to recover the same from the owner, this court considers desirable to allow the appeal in part, ordering pay and recovery. Full stop. Thus, the appeal is disposed of.
But interest 7%, no, that may be 6%.
Next one. Learned Counsel Sri B. Pradeep also raised a plea with regard to grant of interest. Full stop. The tribunal ordered the insurance company to pay the awarded amount of rupees 5 lakhs with interest at the rate of 7% per annum. Full stop. However, the interest to be awarded should be in consonance with the banking rate of interest at the relevant period. Full stop. Therefore, this court is of the view that the awarded amount is liable to be paid with interest at the rate of 6% per annum. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The appellant is directed to deposit the total compensation of rupees 5 lakhs with interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, on such deposit, the appellant is permitted to recover the same from the second respondent, oblique the owner of the vehicle, by initiating appropriate proceedings.
Amount in deposit will be transferred.
The amount, if any, in deposit be transmitted to the concerned tribunal immediately.
Placement.
My lord, serial number 59, my lord.
Next.
Serial number 61,
I prefer,
DN Nagaraj.
I prefer respondent, your lordship.
Yes.
This is the injury case, your lordship. Pardon, your lordship. Last occasion I have not.
Yes.
This is only the, your lordship, that made a chart and enhanced some portion, that's all. Because he has injured is in a clavicle bone fracture.
No representation on appellant side.
But they have not come forward in the so many occasions. You kindly see the order sheet also, and this one. I already argued the matter before other bench also. In spite of that, lordship, that's why.
No representation on appellant side on call. There
Only-
was no representation even on 29/7 and 9/8. Full stop. Sri C.R. Ravishankar, Land Counsel for Respondent number 3, submits that the appellant is not evincing any interest in the matter. Full stop. Record discloses justification in the 18(9) under the caption for dismissal.
Serial number 62, Girimallaya.
Appearing for the
D.
R2,
Jayaraj,
your honor.
Ashok,
Respondent number
Ashok and
2.
Patil for R1.
Yes, mister. You have not filed wakalat.
Mallards, I am instructed to Mallards go ahead with the matter. Mallards, if he is present. we
No
can-
representation on appellant.
This is a case, Mallards, where they are seeking enhancement, as well as, Mallards, there is pay and recover order in this case. Because the insured, Mallards, driver was not holding a valid and effective driving license.
Appearing for the respondent number 2, your honor.
No representation on appellant side on call. To give fair opportunity, list on 11th September.
Serial number 63, BC Shivannegowda.
I appeal for the plaintiff. Plaintiff insurance company.
Yes.
Appellant insurance company challenging the pay and recovery order. Since my lord,
Records
the
not
court,
proceeding. Yes,
since the pay and recovery order has been passed by the court below on the ground that my lord, the pillion rider, risk of the pillion rider is not covered. Court has come to conclusion, pillion rider risk is not covered, it is only a MAC policy. But pay and recovery order has been passed. It is against to the apex court judgment, where the apex court, when the premium was not covered, the risk is not covered, court is the,
where is the decision to that effect?
I place it, my lord. The records vanilla,
Records not received.
awaiting for the records.
When records were called for?
6,000.
Await records from the consent tribunal. Registry is directed to issue reminder. List on 21st October.
Serial number 64. DC Sitaram Rao.
Manoj, I appear for the appellant Manoj in this matter.
Respondent served under
Case of injury. Manoj, the injured himself was the owner of the vehicle as of the date of accident. Yet, Manoj, the appellant has been made liable to pay the compensation. He admits in the cross-examination that he purchased the vehicle 3 months before the date of accident. RC was not transferred into his name.
Yes. Yes, Mr. Counsel, please proceed with your submission.
Sir, Sitaram Rao, sir. Anup, sir, ಹೇಳಿ.
Manoj, may I take your lordships to PW and cross-examination, Manoj?
Record available?
No.
Yes, Mr. Counsel, please proceed.
Manoj, the examination in chief and cross-examination is in Kannada, Manoj. I may have to file a translated copy.
Land Counsel Sri Anup Sitaram Rao appears through VC and seeks time to file translated copies of the documents over which he relies upon. Hence, list on 21st October.
Much obliged, Manoj.
Number 65, Girish Baldare.
For
Ashok and
appellant, my
Patil.
lord.
Appearing for the response.
Case of injury, my lordship.
Yes.
The claim petition came to be dismissed. On the 3 grounds, my lordship. First one is in the history of RTA, it is mentioned as self-fault from bike. And second contention is there is a delay of 7 days in lodging the complaint. And third one is the petition under the influence of alcohol. And taking no, and under the influence of alcohol. Is not the rider, is the pillion rider of the motorcycle, in which is proceeding along with the rider in a motorcycle belongs to his cousin. Thereby, due to applying of sudden brake, the accident has been took place. Thereafter, he was shifted to Vadayanarshipura Hospital, where he initially we took the first aid.
And it is the information given by some other person who took the hospital, that is the driver of the motorcycle. And as per the information given by him, it is mentioned as the cell fall from the bike, which is in exhibit R2, my lord. Which is marked as exhibit R2. Immediately they have the exhibit R2, which is produced on behalf of the insurance company, where it is indicates that cell fall from bike at about 440 cm on 13/1/2009 near government hospital. And some overrating has been made at the
Government bus stand.
government bus stand. Thereafter, he was immediately shifted to Sparsh Hospital. And nothing was mentioned in the Sparsh Hospital apart from saying that RTA two-wheeler pillion rider
Bus stand ಅಲ್ಲಿ
bus stand ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲಿನೂ overwritten.
Self fall ಅಂತ ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ. And the very same day, he was shifted to Sparsh Hospital for taking higher treatment. In the said history, nothing was stated with regard to the cell fall and other information. And as a specific explanation offered in the complaint, stating that the delay caused due to which he was providing treatment at hospital. Hence, he could not lodge the complaint immediately after the accident. That was the explanation offered in the while lodging the complaint before the jurisdiction police. And apart from that, the driver of the offending motorcycle was promised to reimburse the medical expenses. Hence, he requested to not to lodge the complaint. When he was not come forward to settle the medical bills, then only the complainant intending and lodge the complaint. Hence, there is a specific reasons assigned in the complaint for delay in lodging the complaint. And though it is mentioned as cell fall in the first instance, subsequently on the very same day he was admitted to another hospital at Bangalore, Asan. Nothing was mentioned there, my lordship, in Sparsh Hospital. And he was not riding the vehicle. And what extent of alcohol is consumed, that was not forthcoming in any of the record. And he was not the rider of the motorcycle, he only the pillion rider of the motorcycle. And he sustained the injuries of vertebra, fracture of C4, C5, C6, C7 vertebra, and fracture of neck. The doctor also examined to that effect, and he assessed the disability to the extent of 25%, my lordship. And the compensation is not been determined by the tribunal while dismissing the claim petition, my lord. And there is no suggestion with respect to the cell fall by the insurance company while conducting the cross-examination of the doctor who treated as the PW2. Who brought the patient to the hospital and what occasion they have made to write it is in the street as cell fall. Nothing was suggested by the insurance company during the course of examination, my lord. And apart from examining the official witness, no other independent witness are examined to disprove the case of the claimant, my lord. The tribunal, by relying on the exhibit R2, the other aspects of the case has been completely disputed by the tribunal. crucial document which is relied upon by the insurance company is only exhibit R2. Where the claimant was initially took the treatment at Shipra and immediately was shifted to Sparsh Hospital at Asan. If that is so, then it has to be carry forwarded in the case sheet of Sparsh Hospital, but nothing was mentioned.
May I? 1 minute.
The complaint though it is in Kannada, but it is specific explanation offered. What is the reason for delay? No, ದೊಡ್ಡಪ್ಪನ್ ಮಗ.
ನೋಡಿ. Belonging to the complainant. The complainant is the grandson of the.
And the complainant is the cousin. There is no bar that.
Complainant is not a cousin. That's paragraph 4.
ಅಲ್ಲ cousin ಅಲ್ಲ ಹೇಳ್ತೇನೆ ಬನ್ನಿ.
My lord, on 13/1/2019, the accident has.
1 minute.
Yes,
ಚಾಲಕರಲ್ಲಿ ರೋಹಿತ್ನ ಸ್ನೇಹಿತನಾಗಿದ್ದು ಕಂಪ್ಲೇಂಟ್ ಇದೆ. ಮಗ ರೋಹಿತ ಕಂಪ್ಲೇಂಟ್ ಇವನು ದೊಡ್ಡಮ್ಮನ ಮಗ. Complainant ತಾಯಿ ಹೆಸರಲ್ಲಿ. It is belongs to the complainant ತಾಯಿ ಹೆಸರಿನಲ್ಲಿ. ಚಾಲಕ ರಂಜಿತ್ ಏನು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಓನರ್ ರಂಜಿತ್ ಪ್ರಾಮಿಸ್ ಟು ಪೇ.
Yes. Yes, Mr. Council, what is your submission?
With regard to the delay, my lordship,
Keep
the
aside delay,
6 days delay, my lordship.
keep aside. What about that influence of alcohol?
The influence of alcohol is not by the rider, is the pillion rider, my lord.
Pillion rider only.
To what extent he was influence of alcohol, that is not forthcoming, my lordship. It is only stated in the exhibit P13, 12. Patient is under the influence of alcohol.
Alcohol.
The percentage
P20
of influence of alcohol is not stated in the case sheet. And it is also the fact that he is not the rider of the motorcycle. The motorcycle was ridden by his friend and he is only the pillion rider. The accident, if he is driving the vehicle, then by the influence of the alcohol, then accident could have been taken place. That is the other aspect, my lordship. But in the instant case, he was not riding the motorcycle. His friend is riding the motorcycle, then the influence of the alcohol cannot come to the part of the ration negligence by this claimant, my lordship. And other aspect, my lordship, in the case sheet, initially he was took to the Alenarshipur hospital where he was admitted as a patient for taking first aid, where it is by the information given by some other person, might be as it is indicated that it is a self-fall. Thereafter, he was immediately shifted to Sparsh Hospital at Asan. Nothing was brought before the Asan Sparsh Hospital regarding the self or any other aspect mode of the accident taken place by the two-wheeler. And it might be both the rider and pillion rider was proceeding in a motorcycle. By oversight, they have given information that by self-fall, it is an accident took place. It is not given by the injured. It is by the some other person who took the injured to the hospital may have give the information to the hospital. Same is noted down in the case sheet, and the patient was forwarded to the Sparsh Hospital for taking higher treatment, where nothing was mentioned. And in this aspect, no contra evidence led by the insurance company, apart from producing the exhibit R2 before the tribunal. Even otherwise, no single suggestion put to the medical officer who examined before the tribunal as a PW2. Only because of that, entire other claim petition cannot be disbelieved. Other aspect of the which is produced by the claimant cannot be ignored, my lordship. And there is no dispute but the accident has been taken place. He was sustained some injuries in the accident, and to that effect, doctor has been examined. In spite of the police records against the rider of the motorcycle, and vehicle was seized and some damage is caused as per the IME report. By disbelieving all those documents, the court below come to the conclusion that the involvement of the vehicle is not proved by the claimant, and claim petition is dismissed. By considering the other aspect, my claim petition came to be allowed, and compensation has to be determined in accordance with law, my lord.
So your contention is that he should be paid compensation Though he, under the influence of alcohol, he travels, even as per your version, as a pillion.
But some contribution, some
Then-
extent of contribution has to be attributed against the petitioner, if that is so. But cannot be denied the paying compensation
Charge sheet
in
is
all
lied.
my lordship.
Whether any charge sheet is lied?
Charge sheet is against the rider of the motorcycle, my lord. That has not been challenged by the claimant, sorry, insurance company.
What do you say, Amma, in this regard?
My lord, the accident has taken place on 13/1/2019, my lord. At the time of filing the complaint, the vehicle belonging to the aunts of the petitioner, my lord. My lord, they have taken a 6 days time to implicate the rider of the motorcycle, my lord. He was riding the motorcycle with the influence of the alcohol. He met with the accident and he has sustained the injuries, my lord. Immediately after the accident, he was admitted to the Hole Narsipura Government Hospital, where it is clearly stated, my lord, he was a self-fall from the two-wheeler, my lord. Subsequently, my lord, they have not filed the complaint immediately after the accident to take a time to implicate the rider of the motorcycle, my lord. And they have stated in their complaint, they says that the owner and the rider of the motorcycle wanted to pay the compensation. For that reason, we have not paid. My lord, on the complaint itself, it is stated that the vehicle belonging to his mother's sister's vehicle, my lord. The question of paying the compensation by the owner of the vehicle, my lord, will not be arised. They have taken a 6 days time to implicate the rider, my
No,
lord.
sorry, it is not stated as a owner, it is stated as a rider.
Council, let the submission be complete.
And my lord, in the complaint, the exhibit R2 clearly says that, my lord, he who was accompanied by him, he has clearly stated that history of RTA, self-fall from the bike at around so and so, my lord. Subsequently, he was admitted to the Sparsh hospital and they have stated that they have implicated he was a pillion rider, my lord. The petitioner himself, the MLC belonging to the first hospital is very much important in medical legal cases, my lord, where it is clearly says that self-fall, my lord. Based on that, my lord, the tribunal has discussed, my lord, and dismissed the claim petition. My lords may kindly see the paragraph number 19, my lord, where it is clearly stated, my lord, it is a clearly self-fall case and under the influence of the alcohol, he himself was riding the motorcycle with the influence of the alcohol. The dog came in between and he applied the brake and he fell down and sustained. That is their contention, my lord. He was not a pillion rider, my lord. He was a rider of the motorcycle.
How can you say that he is a rider?
Yes, my lord. If that being so, my lord, the rider also admitted along with the petitioner, my lord, on perusal of the MLC extract of the Hole Narsipura, my lord, there was no MLC extract pertaining to the rider of the motorcycle, my lord. He would have also sustained the injuries, my lord. And the burden lies on the petitioner, my lord, when we have taken a specific contention, he was a rider of the motorcycle.
What about the contents of the charge sheet?
The contents of the charge sheet is against the insurance company, the motorcycle rider only, my lord.
Then
We are not a part of the charge sheet to challenge, my lord. When the owner himself has colluded with the claimant, my lord, he will obviously he will not challenge the charge sheet, my lord. That was the contention. The insurance company is not a part of the charge sheet, my lord. They cannot file the challenge the charge sheet, my lord. My basic contention before this honorable court, my lord, the owner and the claimant, they themselves are colluded together and filed the false charge sheet, my lord. And admittedly, he was colluded with the claimants, my lord. He will admit the charges against him, my lord.
Yes.
If that is the case, they would have challenged the charge sheet, my lord. Charge sheet is laid against the rider of the motorcycle. And even the rider of the motorcycle will be prosecuted for the offence alleged against him.
So
That was not challenged by the insurance company.
on hearing both
Even
sides.
otherwise in the
Yes,
complaint.
Mr. Council, we have gone through the record. On hearing both sides, we are fixing liability of 50% on part of the claimant. So
50% is-
No, my lord, it is a clearly self-fall, my lord, no other.
Already we heard. So 50% of the amount which the claimant is entitled to would be paid by the insurance company. And we are remanding the matter to the tribunal to fix the compensation.
No, my lord.
50% is an higher side, my lord. It is 75-25, it may be.
No, my lord, only one vehicle was involved, my lord. The the petitioner himself was riding the motorcycle, my lord. The MLC extract, which is clearly shows, my lord, as per exhibit R2, my lord, immediately after the accident, he was admitted to the hospital, my lord, where it is clearly stated that self-fall, my lord. It is not stated a pillion rider also, my lord. The question of liability on the insurance company will not be arised, my lord. He himself has fell down, my lord. He himself was riding the motorcycle with the influence of the alcohol, my lord. The question of challenging the charge sheet will not be arised, my lord, because the insurance company is not a part of the charge sheet, my lord.
You need not challenge the charge sheet, Amma.
Yes, my lord.
Yes. Third. Sri Girish P. Baldari, Land Counsel for the appellant, as well as your good name, Amma?
Padma Uttur.
Miss Padma Uttur, Land Counsel, who represents Sri Ashok and Patil, Land Counsel, on record for respondent number 1. Next. Disputing the validity and the legality of the order that is passed by the Additional Motor Accidents Claims Tribunal Hassan in MBC 660 of 2019, dated 29/11/2021, this appeal is filed. This is a claimant's appeal. Next. The matrix of the case, as projected by the appellant before the tribunal, is that on 13/1/2019, at about 3:45 p.m., while he was proceeding as a pillion on a motorbike bearing registration number KA13EM 7771, the rider of the said motorcycle by name Ranjit rode the same in a rash and negligent manner, and when a dog came in front of the said vehicle, he suddenly applied brake, due to which he, who was present on the bike as a pillion, fell down and suffered grievous injuries. Next. Next means next paragraph. The tribunal, subjecting the evidence of PWs 1 to 3, RW1, exhibits P1 to P17, and exhibits R1 to R3 to scrutiny, came to a conclusion that the appellant is not entitled for any compensation either from the owner of the vehicle, that is respondent number 1 herein, or the insurer of the vehicle, that is respondent number 2 herein, and thereby dismissed the claim petition. Next page. Arguing the matter, Sri Girish P. Baldari for appellant submits that the tribunal dismissed the claim petition on 3 grounds. Firstly, that the appellant sustained injuries due to self-fall, secondly, that there is delay in lodging complaint to police, and thirdly, that the appellant was under the influence of alcohol at the time of accident. Land Counsel states that the appellant was not riding the bike which was involved in the accident. Indeed, he was a pillion rider. Full stop. Therefore, the appellant being under the influence of alcohol is not a fact to be taken into consideration by the tribunal to exonerate either the owner of the vehicle or the insurance company from liability. Full stop. Learned counsel also states that as the appellant sustained grievous injuries and was shifted to different hospitals, he could not give complaint to police immediately, and that does not mean that the appellant foisted a false case against the rider of the motorcycle. Full stop. Learned counsel also states that the appellant is not the author of exhibit R2 information. Exhibit R2 contents wherein it is mentioned that the injuries sustained were due to self-harm. Full stop. Projecting thus the learned counsel for the appellant seeks to set aside the impugned order and fastened liability against the respondents 1 and 2. Next. Vehemently opposing the submission thus made, Miss
Padma Uttur,
representing the insurance company, contends that due to the negligence on part of the appellant, the accident occurred. Full stop. Learned counsel,
he himself,
Miss Padma
he
Uttur,
himself was riding the motor.
Miss Padma Uttur also states that the appellant was indeed driving the motorcycle which was involved in the accident. Full stop. He, under the influence of alcohol, rode the motorcycle in a rash and negligent manner, fell down and sustained injuries. Full stop. Learned counsel also states that due to the reason that the appellant fell down from the motorcycle under the influence of alcohol and sustained injuries, he did not give complaint to police immediately. Full stop. After thought, with inordinate delay, he gave complaint to police, which itself goes to show that a false case was foisted, a false complaint was lodged in collusion with the owner of the motorcycle for illegal gain. Full stop. Learned counsel contends that the tribunal thus rightly dismissed the claim petition.
Owner of the vehicle is none other than the aunt of the.
And therefore, the impugned order needs no interference. Full stop. Next. As per the contents of Exhibit R2, MLC, the injuries sustained were due to self-fall from the bike. Full stop. However, as rightly projected by learned counsel for the appellant, there is no mention about the source of information from which the authorities of the hospital made a mention that the accident occurred due to self-fall from bike. Full stop. However, the fact that is clear is that the appellant was under the influence of alcohol at the relevant time, that is when the accident occurred. Full stop. The contents of Exhibit P14, Exhibit P20 within brackets small letter A and Exhibit P20 within brackets small letter C all reveal that when the appellant was seen, that is on the date of accident itself, it was found that he was under the influence of alcohol. Full stop. The accident admittedly occurred
On 13/1/19.
around 3:45 p.m. Full stop. The doctors of Dispatch Hospital examined the appellant around 6 p.m. and even at that time, it was found that he was under the influence of alcohol. Full stop. Therefore, it can be clearly inferred that even after 2 hours, he was found under the influence of alcohol, he should have been under the high influence of alcohol and not minimal as projected by Sri Girish B. Baldari, Learned Counsel for the appellant.
May make one submission.
Though, when we have started dictating the order, we will not entertain. Next para. Though, Learned Counsel Sri Girish B. Baldari contended that as the appellant was a pillion rider and not the rider of the motorcycle, he being under the influence of alcohol should not be considered. Yet, a person who is a pillion would be under requirement to sit properly on the vehicle over which he travels. Full stop. A person under the influence of alcohol cannot be expected to sit in a proper manner as that of a normal person. Full stop. Therefore, it can be inferred that the appellant also contributed for the fall from motorcycle and for sustaining injuries. Full stop. This observation of this court is due to the fact that it is not the case of the appellant or either of the parties that the motorcycle hit any other vehicle and thereby the appellant fell down. Full stop. Therefore, this court is of the view that the appellant has contributed for such a fall and for sustaining injuries. Next. Though Ms. Padmavati argued that the appellant was driving the motorcycle at the relevant time, yet having considered the fact that after investigation, police found that the appellant was a pillion rider and that the motorcycle was being driven by another person, this court is of the view that the said contention cannot be appreciated. Full stop. Having considered, next paragraph, having considered the manner in which the accident occurred and that the appellant was under the influence of alcohol while sitting on a motorcycle which was proceeding on the road, this court is of the view that his contribution for the injuries sustained by him should be to an extent of 50%. Full stop. Therefore, this court holds that the owner as well as the insurer of the motorcycle are at liability to compensate the appellant to the extent of 50% of the compensation which the appellant is entitled to for the injuries he sustained. Full stop. Therefore, this court holds that the findings of the tribunal that the appellant is not entitled for any compensation is required to be interfered with. Full stop. However, as the duty to fix the justifiable amount as compensation is upon the tribunal, this court considers desirable to remit the matter back to the tribunal for consideration of the amount which the appellant is entitled to and to order the insurer as well as insured of the motorcycle to pay 50% of the same as compensation to the appellant. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed. The award, the order that is passed by the additional motor accidents claims tribunal Hassan through orders in the order that is rendered by the additional motor accidents claims tribunal Hassan in MBC 660 of 2019 dated 29/11/2021 is set aside. Full stop. The appellant is entitled to compensation to the extent of 50%. The negligence, the contributory negligence on part of the appellant is fixed as 50%. Next, the appellant is entitled to 50% of the compensation from the respondents. Full stop. The tribunal is directed to appreciate the evidence that is brought on record with regard to the entitlement, with regard to the quantum which the appellant is entitled to. Full stop. On such fixation, respondents are jointly and severally liable to pay 50% of such compensation, along with the interest which is fixed by the tribunal. Full stop. The tribunal is directed to dispose of the matter within a period of 3 months from the date of receipt of copy of this order.
Rest of the 50% is liability saddled on the owner of the offending vehicle. 50% is on the insurance company. Remaining 50%, Lordship may be ordered to remaining 50% is payable by the owner of the offending vehicle.
Because you have taken alcohol, the owner should pay. Yes, Mr. Counsel, how can it be?
Serial number 66, Pawan Kumar YN, HC Betsur.
For appellant, my lord.
For respondent.
Case of injury, my lord.
One sufficient. Betsur is appearing, my name immediately for the insurance company.
Appeal filed for enhancement of compensation. The accident was occurred on 9/4/2019 due to rash and negligent driving of the offending vehicle. The tribunal has awarded $15,63,000 after deducting the 30% contributory negligence. Total award is 22,33,780. After deducting the 30%, the award amount is 15,63,646. Petitioner is the PW 1 year.
So what is your contention, Mr. Counsel? On what grounds you have filed this appeal?
Tribunal has taken 12,000 per month income, my lord. Accident is in the year of 2019. Notional income is the 14,000. And disability, doctor has assessed the disability at 29%. Percent to the mid face, 30% to the left arm, 52% to the left lower limb, and 29% to the whole body.
Hmm.
Tribunal has taken only 29%. But mid face disability did not taken, my lord. There are multiple facial injuries. Fracture of frontal bone, fracture of nasal bone, fracture of bilateral maxilla with hemosonis, and comminuted displaced fracture of left distal end of femur with intra-articular extension, segmental middle displaced fracture of mid shaft of left humerus. The whole body disability is 29%, and tribunal only taken that 29% disability, my lord. Not taken 5% mid-face disability. On that ground only, appeal has been filed with for enhancement of compensation. And also tribunal has awarded meager compensation for future medication also.
So the tribunal took the disability as 29%.
29%.
Notional income as 12,000, no?
Yes, my lord. Has to be taken 14,000.
Yes, Mr. Counsel.
So far as income, my lord, as per the chart, it can be taken. My lord, here, the discussions, records for the yes, sir. In that, my lord,
So
as per the
2019,
discussions,
14,000.
I don't have any. My lord, what the tribunal taken regarding the disability, my lord, it is proper. Whole body disability,
29%.
29%. As it is taken.
Yes.
So far as disability is concerned, it is rightly taken. Then, my lord, under the head, loss of amenities, my lord, awarding 1 lakh is on higher side, my lord. It can be readjusted.
You have not filed any appeal. You have not filed any appeal.
Yes.
You have not.
So far
filed-
as tribunal order, we have in that context, my lord, I was satisfied. While reassessing, my lord, I am making this submission, my lord. Amenities, loss of future happiness, amenities and marriage prospectus. It doesn't mean that fracture to the leg, he will be having no marriage prospectus.
So many injuries, Mr. Counsel, not only to the
5 previous injuries, my lord.
What was his occupation by the date of
Is
accident?
agriculture and milk vending, he says, but not proved. Even though, my lord, there is no estimation for future medical expenses, the tribunal awarded sufficiently
As
75,000.
assessed in the affidavit itself,
75,000.
my lord. 1,50,000 stated.
So we have taken the notional income as 14,000. We have not disturbed the disability. Disability is taken as 29% only. So on calculation, he will be entitled for an enhanced sum of 4,75,964.
And so far as contributory negligence is concerned, there is no document has been filed by the respondent number 2. And there is no evidence also, my lord. IO ಕೂಡ examine ಮಾಡಿಲ್ಲ, ಐ ವಿಟ್ನೆಸ್ ನು examine ಮಾಡಿಲ್ಲ.
Not required. By going through the
Even-
police documents, the
Yeah,
tribunal
charge
has
sheet
come
ಅಲ್ಲೂ
to
ಇಲ್ಲ.
the
Charge sheet
conclusion.
in favor of the petitioner, your honor.
Charge sheet is not a conclusive proof. Actually, this
Charge sheet
accident
is
happened
only
because of
against
rash
the
negligent riding
rider
of-
of the offending vehicle.
He himself was riding. He entered the road without observing the vehicles on the road. My vehicle was going straight.
Kindly see the
Actually, it
exhibit,
should have been 50% contributory
exhibit P4, my
negligence.
lord. Sketch, spot measure.
In para 11, it is categorically stated. My
In the
vehicle was,
spot measure, they have stated that ಕೃತ್ಯ ನಡೆದಿರುವ ಸ್ಥಳದಿಂದ ಪಶ್ಚಿಮಕ್ಕಾದಂತೆ 5 ಅಡಿ ದೂರದಲ್ಲಿ ಸದರಿ ಮೈಸೂರು ಬೆಂಗಳೂರು ಡಾಂಬರು ರಸ್ತೆಯ ಪಶ್ಚಿಮದ ಅಂಚು ಬರುತ್ತದೆ. ಕೃತ್ಯ ನಡೆದಿರುವ ಸ್ಥಳದಿಂದ ಪೂರ್ವಕ್ಕಾದಂತೆ 19 ಅಡಿ ದೂರದಲ್ಲಿ ಡಿವೈಡರ್ನ ಉತ್ತರದ ಅಂಚು ಇರುತ್ತದೆ. That means already 19 feet he has crossed, my lord.
Mr. Counsel, there is well-reasoned order in respect of the aspect of negligence, which needs no interference.
There is no document or there is no evidence, my lord, in that regard.
Heard. You are Mr. Pawan Kumar?
Yes, ma'am.
Heard. Sri Pawan Kumar YN, Land Counsel for the appellant, as well as Sri H.C. Bensur, Land Counsel for respondent number 2. Next. This is a claimant's appeal. Full stop. Dissatisfied with the amount that is awarded as compensation, comma, the claimant is before this court challenging the order that is rendered by the Additional Motor Accidents Claims Tribunal, Bangalore, in MVC 3618 of 2019, dated 12/4/2022. Full stop. Undisputedly, the appellant sustained a lacerated wound over scalp and forehead with soft tissue loss, comma, fracture of frontal bone, comma, fracture of nasal bones, comma, bilateral maxilla with hemosinus, comma, comminuted displaced fracture of left distal end of femur with intra-articular extension, comma, segmental middle displaced fracture of mid shaft of left humerus and thin subdural hemorrhage along with left temporal convexity. Full stop. Next para. Arguing the matter, Sri Pawan Kumar YN submits that the appellant, by attending agricultural works and also by selling milk, was earning rupees 20,000 per month. Full stop. However, due to the injuries sustained, he became permanently and totally disabled, and therefore he is not in a position to attend any work. Full stop. Though the appellant produced the evidence of PW3 to establish the aspect of disability, the tribunal considered the permanent functional disability as 29% and awarded meager sum as compensation under the head loss of future earnings. Full stop. Land Council thereby seeks for enhancement of compensation. Full stop. Land Council also contends that the Karnataka State Legal Services Authority is taking the notional income as rupees 14,000 for the relevant period, that is for 2019, and at least the said figure should have been considered by the tribunal. Full stop. Next. Sri H.C. Bensur, on the other hand, contends that the tribunal, appreciating all the evidence, has come to a conclusion that appreciating all the evidence, came to a conclusion that the disability in respect of whole body is 29% and that is justifiable. Land Council also states that the appellant did not produce any evidence with regard to his occupation and earnings by the date of accident. However, Land Council did not raise any objection for taking the notional income as rupees 14,000 as pleaded by Land Council for the appellant. Next, a perusal of record reveals clear discussion by the tribunal with regard to all the aspects of the case and also the percentage of disability which has to be taken towards as permanent functional disability. Full stop. Therefore, this court does not find any grounds to interfere with the finding given that the permanent functional disability is 29%. Full stop. However, the tribunal took the notional income as rupees 12,000 per month. Full stop. This court, basing on the submission made by both the Learned Council, intends to take the notional income as rupees 14,000 per month. Full stop. Also, the tribunal failed to add future prospects. Full stop. Admittedly, the appellant was aged about 22 years by the date of accident. Full stop. Therefore, 40% of the earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case. You have to write full form. Pranay Sethi's case. Full stop. The appropriate multiplier to be applied is 18. Full stop. Thus, the amount which the appellant is entitled to towards loss of future earnings due to permanent physical disability is as under. Notional monthly income, tabular form, 14,000, annual income 1,68,000, add 40% towards future prospects, 2,35,200, apply appropriate multiplier 18, 42,33,600, loss of earnings, loss of future earnings, the permanent functional disability being 29%, 12,27,744. Next, the tribunal awarded a sum of rupees 7,51,780 only towards loss of future earnings. Full stop. Thus, the enhancement would be 4,75,964 within brackets 12,27,744 minus 7,51,780. Full stop. Next, the contributory negligence on part of the appellant is 30%. Full stop. The tribunal fastened the liability upon the respondents to an extent of 70% only. Full stop. Thus, the enhancement will be 3,33,170, 174.8. Rounded to 3,33,178 within brackets 70% of 4,75,964. Brackets close. Full stop. With the foregoing observations, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the motor accidents claims by the Additional Motor Accidents Claims Tribunal, Bangalore, through orders in MBC 3618 of 2019, dated 12/4/2022, is enhanced by 3,33,175. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, the second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next,
Entire
on
amount.
such deposit, the appellant is permitted to withdraw the entire amount.
My lord, that after deducting 30% contributory, enhanced amount.
After deducting, you have to pay 3,33,175.
And direct the office to delete the name of Sri H.S. Lingaraj.
Already order is dictated. No question of adding that. 68, yes.
One time, my lord, is the body, my lord, appellant comes.
You are representing?
Behalf of, I am appearing for respondent, my lord, but behalf of the appellant is one time, my lord.
My lord, serial number 67, my lord.
1 minute, Mr. Counsel. So 68, you are for respondent, sir?
Respondent, behalf of the Chandrasekhar, my lord, I am
Yes.
appearing. But his appellant counsel also is today inconvenience, my lord, is
Land Council, your good name, Mr. Counsel.
Jagdish Ji. Kumar.
Land Council Sri Jagdish representing Sri Chandrasekhar, or Land Council on record for respondent number 1 in MFA 5776 of 2022, who is also appearing for the appellant in the connected matter 6 times. Hence, stand over to stand over to 21st October.
Serial number 70, my lord. Matter may be referred to Lok Adalat, my lord. We'll settle it, my lord.
70.
I'm for the respondent insurance company, ma'am. I represent.
Your good name, Mr. Counsel.
Jagdish, PS,
Sri
Jagdish PS.
Jagdish for respondent number 2 seeks to refer the matter to Lok Adalat, full stop. Hence, the matter is referred to Lok Adalat for settlement.
Much.
Yes, Mr. Vijay Kumar.
My lord, serial number 67, my lord.
67. Yes.
Yes, my lord. Miss Renuka is appearing for the respondent. She already filed wakalat.
Yes.
My lord, my name may be deleted.
Yes, yes. We'll see afterwards.
Much obliged.
ಯಾರ ಅಂತ ಹೇಳಿ ಮೀಟಿಂಗ್ ಮೇಲೆ ಆಯ್ತು. ಹೌದ್ರಲ್ಲಿ ಅವ್ರು ಬೇಕಂದ್ರೆ ಹಿಂಗೆ ಇನ್ನೊಬ್ಬರ ಮೇಲೆ ಹೇಳ್ಬಿಡೋದು ಅಟ್ಲೀಸ್ಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕು ತಾನೆ. ಒಂದು 4 ಇದೆ. Passover matter, serial number 17. Serial number 17, KT Gurudev Prasad.
Who is there?
17, I appear for the appellant. I filed a memo to withdraw the entire appeal.
Sri KT Gurudev Prasad appears online and seeks permission to withdraw the appeal. Full stop. Memo filed to that effect is also on record. Full stop. Permission as praetor is accorded. Appeal is dismissed as withdrawn.
Please.
No. Appeal dismissed as withdrawn. Withdrawn. Full stop. Consequently, IA1 of 2024 is also dismissed.
Serial number 27, Passover matter, Pradeep Kesi. Jagadish HT.
Yes, sir, appellant. I for the respondent.
Yes. What further submission except for enhancement?
Liability fixed on the insurance company. It is already convinced me by producing DL extract.
Where is the DL extract?
It's already on the last occasion produced.
It is, yes, we have heard. Where is the DL extract? So you are convinced by the DL extract? Yes. Heard. Sri Pradeep Kesi, learned counsel for the appellant.
Sampath Kumar. Sampath Kumar.
Sri Sampath Kumar, who represents Sri Pradeep Kesi, learned counsel on record for the appellant, as well as Sri Jagadish HT, learned counsel on record for respondent number 1 insurance company.
Respondent number 2 insurance company.
Okay.
R2 Wakalat. Sri Hari Naidu, advocate for R2.
He's not representing.
My lord has taken up serial number 28, my lord.
27, sir, 27.
I apologize.
Let us call for the record, Mr. Kapil. As well as Sri also admit.
That's already on the last occasion, matters, even quantum
Call
also
for the
calculated.
record from the consent tribunal.
Please.
List the matter under the caption final hearing on 14th October.
Mobilize.
Very good. And remove from the caption part and list matter under the caption final hearing on.
Serial number 28, Karthik V, Gautam Chand SF.
I appear for the respondent number 1.
Yes,
Yes, for the injury.
yes,
Date of accident 14/5/2013.
bit louder, Mr. Council.
Accident date 14/5/2013. Mother and son is going to vehicle, man.
Mother and son?
Injured person.
Injured person, ma'am.
Yes,
My lord, mother and son are not there, my lord. It's one mistake. It's only petitioner, my lord.
Mr. Council, we are hearing the appellant.
I apologize, my lord.
Yes,
My lord,
Mr.
my lord's screen is not visible.
Yes,
Mother petition is the climate.
ಜೋರಾಗಿ ಮಾತಾಡಿ ಸರ್ ಮೈಕಲ್ ಇಂಗ್ಲಿಷ್.
Pain and suffering ಬಂದು 15,000, ma'am.
now this is filed by son.
Yes, ma'am. Varun.
Yes. Yes. What are the nature of injuries sustained by him? Mr. Council, how can it be when if you come here and study the record?
Sorry.
How many years of standing you have, Mr. Council? How many years of
2 years.
standing you have? If you take so much of time to go through the record and submit your contentions in a simple accident case, how can you do big cases like 302 offenses and all?
It is the evidence of the petitioner that on the date of accident,
On what ground you have filed this appeal? On what ground you have filed this appeal?
amount
Amount?
20,000 claiming.
So what do you want from this court?
Extra 20,000 in.
Yes, Mr.
Injuries are simple in nature. Contrary, 20,000 is granted globally, though this may not strictly call for enhancement. The appears that defendant has filed this. Now it's earlier briefs, another 10,000 plus in there. I see. So, PPA court order. He was, he was an inpatient for about 2 days. The hospital. But though the injuries on the operation of the left hand, right lower abdomen, arm and left elbow was treated inpatient from 15/5 to 17/5. Doctor opined is simple in nature. So strictly may not call for enhancement, but since
Yes, Mr. Council. How much you require?
20,000.
20,000 already granted.
Extra 20,000.
Yes, Mr. Sagar.
My lord, I had insurance, my lord. There are no major injuries per se, my lord. Compensation is just, my lord, and that's all I'm saying.
Heard. Your good name, Mr. Counsel?
Naveen, yes.
Heard Sri Ravindra.
Naveen, yes.
Ravi, yes.
Naveen.
Naveen. Heard Sri Naveen, yes. Who represents Sri Karthik V, Land Council on record for the appellant, as well as Sri H.S. Lingaraj, Land Council for respondent number 2, who appears physically before this court. Full stop. Also heard your good name, Mr. Counsel.
Sagar, my lord, please.
Heard Sri Sagar N, Land Council, who represents Sri Gautam Chand SF, Land Council on record for respondent number 1 and appears through video conference. Full stop. Next. Seeking enhancement of compensation. This appeal is filed by the claimant in MVC 842 of 2013, which stood pending before the court of motor accident, which stood pending before Motor Accidents Claims Tribunal, Nagamangala, and was disposed of on 13/1/2017. Full stop. There is no denial of the fact that the appellant sustained a lacerated wound on occipital region, an abrasion on left hand, an abrasion on right lower part of abdomen, an abrasion over left arm and abrasion over left elbow, which are all simple in nature. Full stop. Equally, there is no denial of the fact that the appellant took treatment as inpatient for a period of 3 days. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 15,000 towards pain and suffering, 3,000 towards food, nourishment and attendant charges, and rupees 2,000 towards medical expenses. Full stop. In total, the tribunal awarded a sum of rupees 20,000 as compensation. Full stop. Next, Land Council for the appellant contends that the amount awarded as compensation is on lower side, and hence an appeal is filed for enhancement. Full stop. Though Sri Sagar, representing respondent number 1, and Sri H.S. Lingaraj for respondent number 2, submits that the amount awarded as compensation is justifiable, yet both of them contended that in case the court intends to award additional sum, the same may be minimal. Full stop. Though the appellant sustained only 5 simple injuries, the fact remains is that he took treatment as inpatient for a period of 3 days. Full stop. The tribunal failed to award any amount for conveyance. Full stop. Also, no amount is awarded towards loss of earnings. Full stop. Admittedly, the appellant would not have attended his normal pursuits at least for a period of 10 days. Full stop. Therefore, this court is of the view that the amount awarded as compensation is required to be enhanced globally by 10,000. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is granted by the Motor Accidents Claims Tribunal, Nagamangala, through orders in MVC 842 of 2013, dated 13/1/2017, is enhanced by rupees 10,000. The enhanced amount shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit.
Interest has been denied for free.
Shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit, except for the period of delay of 1067 days as per the orders in IA 1 of 2022 dated 19/1/2024. Full stop. The second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, the appellant is permitted to withdraw the entire.
Pass over matter, serial number 57. H.C. Rishabhendraya, S. Rajshekhar.
Where is the counsel for other side, Mr. Counsel?
S. Rajshekhar, serial number 57.
Yeah, kindly have it next week, my lord. Them come. Yes. I am ready to argue.
Sri H.C. Rishabhendraya for appellant is present before this court physically. Full stop. However, there is no representation on respondent side. Full stop. To give fair opportunity, list on
Short date.
21st October.
Serial number 67. G.J. Sunkapur, H.R. Renuka. Serial number 67.
No representation on either side on call. Full stop. As Srimati H.R. Renuka is on record for respondent in MFA 5293 of 2022, office is directed not to show the name of Sri D. Vijay Kumar in the cast list. Full stop. List both the matters on 12th September.
Serial number 68, adjourn. 69. Ravi S. Samprati, T. Vijay Kumar.
Payment respondent.
Yes.
That the appeal is filed by the insurance company challenging the quantum. The claim petition is filed by the parents of the deceased. The deceased was aged around 27 years. Huh? Chinnamma wife. Amma kana. Huh? Milord, the mother of the deceased is examined as PW1 before the trial court. She has stated in her evidence affidavit on sworn at para number.
Petitioner number 2 is brother, huh?
Ah,
Brother.
brother of the
Mother and brother.
Milord, the accident is of the year 21/5/2019. Deceased was a bachelor. Milord, the only point which is before your lordship is the income determined by the tribunal. The tribunal has determined the income at 14,000 rupees per month.
Accident of the year
21/5/2019.
2019.
19.
Oh.
The notional income is 14,000, my lord.
Oh.
But here, I may be permitted to read out the evidence affidavit of PW1 at para number 5, my lord. I further submit my deceased son Muniraju was working as a computer operator at Panchayat office and earning 10,000 rupees per month. This is their sworn statement. As against this, the tribunal, without assigning any reason, considers the income at 14,000 rupees. That's the only point.
What do you say, Mr. Vijay Kumar? Your case is that he was earning 10,000. How can we take it as 14,000? We'll reduce to 10,000.
More submission will worship. The second petitioner is the brother of the deceased worship. Also dependent the income of the deceased worship. My lordship, as per the apex court of judgment.
Is there any dispute that he died as a bachelor? He died as a bachelor. 50% to be deducted.
For the apex court judgment, even brother of the deceased is also dependent on the income.
But when it comes to bachelor, on 50%.
In fact, Sarla Varma para number 31 is clear on that aspect. Only if it is married, 1/3 to be deducted.
States that even the brother, if dependent, he can be taken into consideration, but not when he dies as a bachelor.
No, in fact, the love and affection 40,000 rupees consortium is given to the brother of the deceased also.
For the NAGMA general. Purchasing order, petition of 40,000. So the second petitioner is done properly.
And apart from that, the interest is granted at 9%.
What is this?
Operating question, right there.
21,85,972. How it calculated? 1,000.
Nineteen lakh 99,200. 200. Well, in fact, the compensation on the head of loss of dependency, even considering 14,000 rupees will come to 19,99,200.
What?
But there is a calculation mistake also on that. Here it is,
Calculation is not proper.
no. Ma'am. That is what I submitted to your lordship on the last occasion. There is a lot of error in the judgment.
We will recalculate and award, Mr. Council.
Please, Miller.
Because the tribunal don't know how it calculated. Made a mess of it. Then consortium, you will get only 40,000.
Each claimant of arbitration.
Each claimant, how can? The total compensation you are entitled to is 15 lakhs 1,000. Yes. You filed appeal seeking enhancement of compensation. Third. In proceeding sheet, you write in MFA 5386 of 2022. Memo on record seeking dispensation of notice upon respondent number 2. Land Counsel Sri Vijay Kumar T submits that as respondent number 1 admitted its liability, notice to respondent number 2 may be dispensed with. Footstop. Having considered the submission thus made, notice to respondent number 2 stands dispensed with, however, at the risk of the appellant. Next. IA 1 of 2023 is filed, seeking the court to condone the delay of 350 days in preferring the appeal. Heard, Sri Vijay Kumar T, learned counsel for the appellant, as well as Sri Ravi S. Samprati, Land Counsel for Respondent number 1, Insurance Company. Gone through the contents of the affidavit given in support of the petition. Instead of having considered the grounds urged, the delay as prayed for is condoned. Next, final order, common order. Both the appeals are the outcome of the order that is rendered by the Motor Accidents Claims Tribunal, Bangalore, in MVC 4733 of 2019, dated 19/4/2022. Full stop. While the insurance company filed an appeal by MFA 5845 of 2022, urging a ground that the amount awarded as compensation is highly excessive, the claimants filed MFA 5386 of 2023 seeking enhancement of compensation. Full stop. Next paragraph. Arguing the matter, Sri Ravi S. Samprati, Land Counsel who represents the insurance company, contends that the whole case of the claimants is that the deceased Muniraju was earning rupees 10,000 per month as computer operator at Panchayat office by the date of accident. Full stop. Land Counsel states that for the reasons best known, the tribunal took the income of the deceased as rupees 14,000 per month, which is unjustifiable. Full stop. Land Counsel also submits that the mother of the deceased got examined herself as PW1, and even in the evidence, she stated that her deceased son, by working as computer operator in a Panchayat office, was earning rupees 10,000 per month. Full stop. Thus, the income of the deceased should be taken as 10,000 per month. Full stop. Land Counsel thereby seeks to revisit the computation of compensation and pass necessary orders. Full stop. Next paragraph. The submission that is made by Sri Vijay Kumar T. Land Counsel for the claimants, on the other hand, is that the amount awarded as compensation is highly justifiable. Full stop. Next, there is no denial of the fact that even in the pleadings as well as in the evidence of PW1, there is a clear mention that the deceased Muniraju was earning rupees 10,000 per month as a computer operator by the date of accident. Full stop. Therefore, when you remove therefore, when the version of the claimants themselves is that the deceased Muniraju was earning rupees 10,000 per month, the tribunal is wholly unjustified to take the income of the deceased as rupees 14,000 per month. Full stop. Next paragraph. It is not in dispute that the deceased was aged about 27 years by the date of accident. Full stop. Thus, 40% of the actual earnings are required to be added towards future prospects as per the decision of Honorable Apex Court in Pranay Sethi's case. Full stop. Also, the appropriate multiplier to be applied as per the decision of the Honorable Apex Court in Sarla Verma's case is 17. Full stop. As the deceased died as bachelor, 50% of the earnings of the deceased are to be deducted towards personal and living expenses which the deceased would have incurred for himself had he been alive. Full stop. Thus, the amount which the claimants are entitled to under the head loss of dependency is as under. Tabular form. Tabular form. No, monthly income 10,000, annual income 1,20,000. Add 40% towards future prospects 1,68,000. Deduct 50% towards personal and living expenses 84,000. Apply appropriate multiplier 17, 14,28,000. Next parama. Thus, the amount which the claimants are entitled to under the head loss of dependency is 14,000 to 14,28,000. Full stop. Together with the said amount, the appellants are entitled, the claimants are entitled to rupees 16,500 towards funeral expenses and 16,500 towards loss of estate. Full stop. The first claimant, being the mother of the deceased, is entitled to rupees 40,000 towards loss of filial consortium. Full stop. Thus, the compensation which the claimants are entitled to under different heads is as under.
Medical expenses to be added.
Okay. Is as under.
73,772.
Loss of dependency 14,28,000. Funeral expenses 16,500. Loss of estate 16,500. Loss of filial consortium 44,000. Medical expenses 73,772.
$15,74,772.
$15 lakhs 78,000.
15,74,000. 78,000.
78,772. 15 lakhs 78,000. Thus, the
Interest at the rate of 6%.
the compensation which the claimants are entitled to is 15,78,772. Full stop. In the light of the foregoing discussion, both the appeals are disposed of with the following order. Full stop. MFA 5845 of 2022 is allowed in part. Full stop. Next, the compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MBC 4733 of 2019, dated 19/4/2022, is reduced from 21,85,972 to 15,78,772. Next, the compensation granted carries interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, the second respondent is directed to deposit the entire sum within a period of 8 weeks from the date of receipt of copy of this order.
It's first respondent, not the second respondent. First respondent.
The first respondent is directed to deposit the entire sum within a period of the insurance company. You write as insurance
Please.
company is directed to deposit the entire sum within a period of 8 weeks from the date of receipt of copy of this order. Next, out of the compensation granted, comma, the first claimant is entitled to rupees 15 lakhs and the second claimant is entitled to rupees 78,772. Next, both the claimants are permitted to withdraw their respective shares on deposit.
Amount in deposit be transmitted.
Amount in deposit, if any, be transmitted to the concerned tribunal immediately. The appeal in MFA 5386 of 2023 stands dismissed without cause. No. Yes, no.